before Ross had ever been interviewed, before any witnesses had been interviewed, before any investigation whatsoever had been done. The head guy, the head of detectives, had already decided the case. He'd already decided that a crime had occurred. He'd already passed judgment. He'd already completely precluded the possibility that this was exactly what it was, an accident. So the detective's daughter's boss, who you heard from, he's wrong. He's wrong for a lot of reasons. The first thing we want to talk about is legally why he's wrong. And that is because in this state, accident is a defense. Accident. This is what the judge is going to tell you that Captain Farrell does not understand. No person shall be found guilty of any crime committed by misfortune or accident in which there was no criminal scheme, undertaking, or intention, or criminal negligence. An accident is an event that takes place without one's foresight or expectation, that takes place or begins to exist without design. If you find from the evidence in this case that the incident that is the subject matter of this case occurred as a result of misfortune or accident, and not as a result of criminal undertaking and criminal negligence, then it would be your duty to acquit the defendant. The Cobb police made a decision right there on the scene. It was never, ever a consideration that this was an accident. And that's why you've seen and heard throughout these weeks that everything Ross said was suspicious. Everything he didn't say was suspicious. Everything he did was suspicious. Everything he didn't do was suspicious. Every way he acted, he reacted. He screamed too hard at the scene. He didn't cry in front of us. He cried in private on tape, but we couldn't measure his tears, so we don't know if it was actual tears. He cried when he was with his wife. We were secretly recording them, but that doesn't count because he was probably just faking that. You saw him in the interview room when they first put him in the interview room and he wept. You saw that. And what I want you to consider is this. If he's putting on some sort of a show for somebody, why is he doing it alone? Why is he doing it in the room after they've closed the door? Detective Stoddard's assessment of the entirety of what occurred that day was no emotion. No emotion. Not going to re-show that 42-minute recording between Ross and his wife. But if you want to see it again during deliberation, you can ask the judge. Mr. Bourne told you in opening and today that really the only thing to consider here is whether this was malice. Based on Ross's words, based on what Ross said, he's guilty of count 3. Well, obviously that's not true and that's not accurate because you heard the interview, you followed along on the transcript, and what Ross said to the detectives over and over was, this was an accident. He pleaded with try to explain that. If it's an accident, it's not a crime. You're going to be given an instruction by the judge, definition of crime. The defendant is charged with a crime against the laws of the state. A crime is a violation of the statute of this state in which there is a joint operation of an act or omission to act and intention or criminal negligence. Why am I telling you that? Why is that important? Because it takes both the physical doing or not doing, and it takes what's up here and here as well. You've got to have both. That's why we have defense in this state of accident. Because if you do the act or don't do the act, which might otherwise constitute a crime, but you don't have in here or in here, the other part, it's not a crime. No person shall be found guilty of any crime committed by misfortune or accident in which there was no criminal scheme, undertaking, or intention or criminal negligence. Ross failed to take Cooper to daycare. That has never been an issue. He failed. He left him in that car. That has never been an issue. There's no question about it. As I told you in opening, and as Ross explained from that very day, he is responsible. He is absolutely responsible. Only him. Nobody else. And he has acknowledged that from day one. He is responsible. But responsible is not the same thing as criminal. It is not. The state has not disproven that this was an accident. It is their burden to do so. And there's a reason why they can't disprove beyond a reasonable doubt that it was an accident. And that's because it was. Ross is charged with murder in 3 different ways. Okay? And what you really need to understand is this. They're all the same. They all the same. We don't have gradations of murder in Georgia. Not first degree or second degree. Murder is murder is murder. Whether he's convicted of count 1, 2, or 3, if he's convicted of any count, they're all the same in Georgia. You need to know that when you're considering his statement. Each count is just a different theory of murder. And the state's entitled to do that. They're entitled to charge in different ways. But we spent 21 days with them charging down 1 track and 1 track alone. This entire trial has been about count 1. The state's theory in this case that Ross intended to kill Cooper. Malice. That's been the state's theory from the beginning. He meant to do it. He intended to do it. That's been their case. That has been what they have tried to sell you throughout this entire trial. And I think it's become very clear that Ross treasured Cooper and had no reason to kill him. Count 2 says it was felony murder count would be that Ross meant to cause Cooper excessive physical pain. He just meant to cause him pain. And Cooper died as a result of that. Well, there's absolutely no evidence of that. That's the laws of the state's theory in the case. Count 3. Ross acted with criminal negligence in committing cruelty to children, and Cooper died as a result. That's what count 3 would say. So what's criminal negligence? Well, Mr. Bourne went over that with you. I'm going to go over it with you again briefly. Criminal negligence is an act or failure to act which demonstrates a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured thereby. So, to be criminally negligent, a person has got to recognize that by what they're doing, or what they're failing to do, it's reasonable to expect that someone is going to be injured as a result. But they do it anyway. In other words, to be criminally negligent, you've got to know there's a danger out there. You've got to understand there's a danger out there. But I'm going to do it anyway. I'm going to do it anyway. And you really need to understand this is a legal phrase with a legal definition. It is not the same as simple negligence. It is not the same thing. We're not talking about being careless. That is not what the definition of criminal negligence is. Let me give you some examples. All right. If I'm going to, if I need to cross a highway at night with my children, and I recognize it's dangerous to cross that highway unless I do it at a crosswalk or a light. I recognize that danger. And I willfully and recklessly, I do it anyway. And my child is struck by a car. Well, I certainly had every reason to believe there was a possibility, very reasonable possibility that child was going to be injured when I decided to do what I did. And even knowing that, I did it anyway. That's criminal negligence. Let me give you another example. Let's say I have my child in the car seat, and I'm taking him to daycare. But I swing by the office just to run in and grab a file. I'm just going to go in and get one thing. Well, I know that when I leave my child unattended in that car seat, I know there's a possibility that somebody could come, thief, bad guy, whatever, and get my child. And I also know that there's a possibility I may go up into that office and something may happen to me. Maybe I get embroiled in an argument or phone call or whatever. It's reasonable to expect that. And meanwhile, my child's going to be alone. And even knowing of those possible dangers, I do it anyway. I go ahead and I go up there and do it. That's criminal negligence. That's willful and wanton. I do it even knowing that there's an expectation, reasonable expectation, that my actions could result in injury. Here, we don't have that. We don't have a willful, wanton, or reckless action or inaction. We don't have that. In the course of pulling out of the Chick-fil-A and getting back onto the road, Ross forgot. He didn't choose to forget. He just forgot. And it doesn't matter. It doesn't matter what he's thinking about. It doesn't matter if he's thinking about sports or politics, work, sex, whatever. Why? Because you don't anticipate that you're going to forgive. That's not how it works. And we got out of the car with Cooper in the back at the treehouse. He'd forgotten. He'd already forgotten. He can't anticipate or expect that Cooper was going to be injured if when he got out, he'd forgotten he was in there. You see, without that knowledge, when he got out of the car, if he didn't have absolute knowledge that Cooper was there, it can't be criminal negligence. He had to have that knowledge. He forgot. And the same goes for the rest of the day. I'm sure that Mr. Moore is going to talk to you about all that went on here today. Listen, it was a regular day. He worked. He went to meetings. He texted. He went to lunch. He sexted. He did the things he would normally do during the day. But if he doesn't know that Cooper's out there, if he doesn't know it, it can't be criminal negligence. Why? Because he can't. There's not that expectation, that knowledge that an injury could result. If he doesn't know, there's no way it can be criminal negligence. He's clueless. And he doesn't take action because he's clueless. And of course, we heard from Dr. Brewer a little bit about false memory. How Ross would have had false memory of Cooper being in daycare during the day. Why? Because it took him all the time. Remember the example about brushing your teeth. Did we brush this morning? Well, we have a memory of it. But is that because we actually brushed this morning, or because we brushed the last 50 mornings? If Ross didn't know that he was in that car, it cannot be criminal negligence. The state doesn't want to really address head-on quite a few enormous problems with their theory. First one I want to talk to you about is that there is no evidence of any kind of hatred or bad feelings or anger, whatever term you want to come up with, any term you come up with. There's no evidence that Ross expressed that toward his son. Every single witness that we heard from in the trial that had any knowledge of the relationship between Ross and Cooper, everyone testified that he was a loving, proud father. Obviously, the family did. Ross's ex-wife, her best friend Angie, Michael and Amy Bagents. You think Ross's ex-wife and her best friend Angie, do you think they're going to come in here and testify for Ross? If for 1 second they didn't mean exactly what they said, that Ross loved that child more than anything, you think they would have ever come in here for him? Listen, Ross ruined that woman's life. He humiliated her in front of the world. He took her son away. You really think she's going to come in here and her best friend is going to come in here and say anything about how much Ross loved his little boy? If they didn't know that this was an accident? about that? Ross's friends, Michael and Billy, they saw the same thing. They testified to it. Co-workers, Jelani, Andre, Brandon, Brian, Winston, Alex, Jason. Ross bragged about Cooper at work. The Laborers Academy. These were the state's witnesses. Azure, Melanie, Kiara, Michelle. Every one of you, every single one of you have been in the position that these daycare workers at Little Lake.
Your Honor, I'm going to object asking them to put themselves in another person's position. That's completely inappropriate.
I sustain the objection.
These ladies that work with children day in, day out, do you think that they have the opportunity to see parents who are engaged in their children's lives, really engaged, and then see those parents who drop and run? You know, pick them up, get out of there. And what did they tell you? They said Ross was a loving father. He'd bring that little boy in, he'd get down on the ground with him. He'd play with him. He'd get him set up. We'd come visit him sometimes at lunch. Everybody that knew him said he loved that little boy more than anything. Well, what about these women on the internet? We certainly heard from Chelsea Doster. She agreed Ross had only positive, loving, reaffirming sentiments about Cooper. Jane Meadows, she was the scorned woman who Ross had previously been close to. What did she say? Cooper was his life. Bragged on Cooper all the time. Ross could not imagine a life without Cooper. Love that baby more than I've seen him love anything. Loved Cooper so much, he wouldn't leave his wife. He wouldn't do that to Cooper. Even the anonymous people on Whisper. He's awesome. Let me show you something. If you want to write these down, you can, because there's so many exhibits. But this is, I'm showing you defendants, Exhibit 65. Okay. This is a whisper that came into Ross's phone that day. Sometime later that morning. Okay? And what does Ross say? Well, I have a son. That joker decided that, hey, I'm going to get up early. He says, oh, you got to love kids. LOL, yeah. How old is he? 2? Oh, what a great age. He's awesome. He's awesome. This is that day. This tells you a couple things. First of all, he's clueless that Cooper's out in the car. He's absolutely clueless. He's communicating with somebody about his son. But it also shows you the state of feelings. He's awesome. So we've heard about the fact that Ross was living a double life. So I would suggest to you this: what we've heard from the people that these women that he communicated with, and whispers like this. If he was living a double life, there appeared to be a constant in both lives, and that was that he loved his little boy. You see, in both of these lives the state wants to tell you about that there's double lives. In both of them, there's something that's the same. Something that's very the same in both. And that's that he loved that little boy. state wants to suggest that Ross wanted to escape from Cooper so bad that he would destroy the treasure of his life. I submit to you this. To do what they're suggesting that he did, knowingly and intentionally, to do that, there's got to be some pretty serious hatred. I don't mean just dislike. I mean, there's got to be some real serious ill will or hatred for that little boy. The kind that would permeate your life and pour out of your pores, that everybody around you would see and hear and know and realize and pick up on, but not one witness has indicated anything like that. What evidence of the state has the state shown you that Ross hated that little boy? Who are the witnesses who rebutted all the testimony that Ross loved his little boy more than anything? You've heard a lot of testimony that Ross was planning a family cruise to include Cooper. You're going to have to really do some mental gymnastics to get around this in the jury room to find Ross guilty of anything here. We heard from Michael Bajents, Ross's brother, Amy Bajents, Leanna Taylor, that during this beach trip on Memorial Day weekend, they talked about planning a cruise. And you heard from all of them. This is what Ross really wanted to happen. He wanted to do this family cruise. June the 9th, you heard there was a group chat where Ross was expressing this interest in getting a cruise together. So you're going to have these with you. Defendants Exhibit 76, group chat, including Ross, Leanna, Michael, and Amy. Oh, let's talk about a cruise. I want this to happen bad. That's Ross on the 9th. June the 9th, Defendants Exhibit 77. Ross is doing actual searches for Carnival cruises, where you actually have to type in words. What was he searching for? June the 17th. State's Exhibit 608. This is the afternoon before Cooper died. Ross is emailing Heather Coyle. My family's looking to go on a cruise around mid-October. When I say family, I mean 9 people. That includes Leanna, Cooper, and I, as well, and my brother, his wife, and his 6 kids. Cooper's only toddler, but I was hoping you could put together a few things together to see what we're all looking at. Any ideas? You remember we heard from Heather Coyle. Ross had actually mentioned this to her a few weeks earlier in a small group at church. And we talk about it, and he searches for it, and he emails. But there's more than that. In the early morning hours of June the 18th. They found this on Ross's phone. And what this is, Defendant's Exhibit 55, it's a screenshot where Ross is searching and looking for passport fees for children under 16. And you heard from Ross's brother, Michael, that they had talked about that, hey, you might need to get a passport. In fact, Michael actually paid for taking his kids, and they got a passport. And of course, that very day of the 18th, when Heather Coyle emails him back with some information about Carnival Cruises, what does Ross do? He starts Googling information about Carnival Cruises again. Why? One, he's planning a family cruise with Cooper. And two, he's clueless that Cooper's out in the car because he's forgot. The police had this information. They knew about these emails on the 17th and 18th with Heather Coyle. And they never bothered to give her a call. How do you explain that? How do you explain that a person that Ross is emailing with about Cooper on the 17th, about a cruise with Cooper on the 17th, and that he receives an email from at 9:35 on the 18th, how do you explain that police never even called the woman? How do you explain that? District Attorney didn't even call her until September, just a few weeks ago. You know, they managed to wrangle up this woman from the University of Alabama that Ross had hooked up with a year, more than a year, before Cooper died. They managed to wrangle her up, get her in here. Tell you how they hooked up in a car. But they didn't even bother to call the woman he was emailing with about Cooper in the hours before Cooper's death. So I will pose this question to you all. Was this investigation and prosecution a search for the truth? Was it? Or was it a search only for what was going to fit the state's theory? Ask yourself that. There's no way around the fact that in the hours before Cooper's death and the weeks before Cooper's death, Ross was planning a cruise to include Cooper. There is no way around it. And to find Ross guilty of murder, you basically have to just ignore it. You just have to ignore it. Like it was never even brought out. Why? Because a person planning to do what they say that Ross did, the kind of person is not planning to take their child on a cruise. Those are inconsistent. Heard that Ross was working with Roger Webb to find a house in a good school district for Cooper. We brought Roger Webb in here, and he told you that Ross's primary issue, his primary concern in looking for a house was good school districts. That was what he was concerned with. Ross's coworkers knew he was looking for a house in good school districts for Cooper as well. He drove his brother Michael Vagets around showing him the area where the good schools were located. You remember Michael was like, well, that's great, Ross, but I live in Tuscaloosa. Leanna told you, yeah, we were looking. Ross was ready to buy. I wasn't ready to buy yet, but he was ready. And Ross's computer was chock full of emails with Roger Webb, which some of them we went over in court. So why? Why didn't the Cobb County Police contact Roger Webb? I think it's a fair question. And I also think it's a fair question to ask, well, was this investigation really a search for the truth? Or just those matters which would be consistent with the state's theory? Because you see, you don't make plans and look for a house in a good school district for your son if you're inclined to kill your son. They're inconsistent. To find Ross guilty, you've got to basically just ignore that. Just ignore it. Like the police did. The state's theory in this case has been that Ross wanted to live a life free of family, free of wife and child, to do whatever he wanted to do. Run around, sex, do whatever. The problem is, Ross was already doing whatever he wanted to do. He was already doing it. And the state has been very, very successful during the course of this trial in proving that. They've proved over and over and over he's doing whatever he wanted to do. He was hooking up when he wanted, even when his wife was at home. The state's made a big deal out of this. They've made a huge deal out of the fact that Leanna's at home texting him about, when you're coming home, getting groceries or whatnot. Ross is hooking up with Danielle Adore. Made a huge deal out of it. But it didn't stop him. Still did it. And as far as Ross was concerned, he kind of had a good thing going. Yeah, he complained about sex in his marriage. A lot. But he enjoyed the family life part of it. We showed you all those pictures, those videos. He enjoyed that part. Enjoyed being a dad. And none of it interfered with his extramarital life. Didn't interfere. He was already doing what he wanted to do. So ask yourself this. If the state's right about this cockamamie theory that he intended to kill his son, what in the world does he gain? What does he gain? What has he accomplished? What is his reward? He's already doing whatever he wants to do. He's going to put himself under this kind of scrutiny and probably destroy his job and his new business and everything? For what? You see, for there to be motivation, there's got to be some sort of payoff or reward. Think about it. What does he gain? A lot of the evidence in this case has come from Ross's phone or computers. And I want, when you're back in the jury room, it's real curious. I want you to think about what that really means. We know there's evidence of the Dr. Ernie Ward PSA video that was on Ross's computer. The link to it, which, by the way, You understand? Ross told the police he had seen that video. And under the circumstances he was being interviewed, it seems pretty normal that he would say, hey, I just saw this. I know about this stuff. Nonetheless, links on his computer. The Whisper app is on Ross's phone. Okay? The Kick messaging app is on Ross's phone. Ross made no effort to somehow wipe or get rid of the link to that video. And this is the real kicker. He doesn't even delete the Kick app on his phone. He doesn't delete the Whisper app. That's where all this filthy information comes from. That's where it all comes from. And he doesn't even bother to delete the apps. And then that very day on the 18th, what does he do? He spends the day putting more filth on his phone. On the Kick app, on the Whisper app. He's adding to it. Leaving it there on his phone. All he's got to do is delete the app. So I think it's a good question for you to ask yourself, why doesn't he? Now, you know what else is on his phone? This image they're talking about here. It's on his phone as well. Makes no effort to delete any of that. Ask yourself why. Isn't the most likely answer because there was no murder underway? He's got no reason to think anybody's going to be looking on his phone. No reason at all. We've seen and heard a lot about the parking lot. I want to bring it to your attention one more time. Ross parks here. Okay. He does a little, comes here, does a little 3-point turn, goes straight in. There's empty spaces right here against that wood line. And we've talked about this several times during the trial. This path back here is where people walk. And if you're parking on this part of the lot, because this was all filled up, if you're parking back here, you've got to walk up here to either get to this building or to get to the front. In other words, you've got to walk past Ross's car. Why didn't he just back into the wood line? If he wanted to secret that car where nobody was going to be able to walk behind it, and we weren't going to have people walking back and forth, why didn't he just back into the wood line? Instead, he parks in the middle of the lot, under the shade tree. It doesn't make any sense. It doesn't make any sense if you're inclined to be suspicious. But it makes perfect sense if he didn't have any idea he'd left Cooper in the car. Because he was just parking. We talked a lot about Ross's routine. You heard testimony about Ross's routine in the morning, routine of going to Chick-fil-A. Ross would drop Cooper off at Little Aprons in the morning. He'd drive to Chick-fil-A. And we know he went there a lot. Remember his friends from work said, oh yeah, he brings in Chick-fil-A every day. His co-workers said he brought it in. In fact, they would joke about hash browns, and Ross would eat at his desk. And we know that he would drop Cooper off first for several reasons. For one, the route. Simply, it wouldn't make any sense for Ross to pass where he would go to Little Aprons go to Chick-fil-A, get his breakfast, let his breakfast get cold while he's going back to drop Cooper off, and then go to work. It wouldn't make any sense. And you remember we showed you 3 receipts. These were in Ross's car. We got 3 receipts for the drive-through that were just sitting in the car from June the 2nd, 6th, and 11th. You remember when we went over these, we compared them to the login at Little Apron. And what did we find out? Well, we found out that one of the days, Cooper didn't even go to daycare. On 2 of the days, Ross had dropped Cooper off first. The login time was before he went to Chick-fil-A. And we know from hearing from the manager, Chris Redden, the manager of Chick-fil-A, we know that Ross went through the drive-thru and came inside the store. He said at least 11 or 12 times that he'd seen him. But he'd never seen Cooper before. Ross had never introduced him. Why? Because Ross rarely took Cooper to breakfast. So ask yourself this. Do you think if there was anybody that worked at Chick-fil-A that had seen Cooper in there on prior occasions? Anybody? Don't you think we would have heard from him? We didn't. We take his daughter to believe that Cooper had not been in Chick-fil-A in June. We have the videos. We know that Ross took him on March the 14th because there was that text to Leanna saying they were going to do their daddy-son breakfast. But there's just no other evidence that he'd taken him between March the 14th and June the 18th. There's no objective evidence of it. And regardless, it was the exception. It wasn't the normal route. Taking Cooper for breakfast was clearly the exception. But it took him on June the 18th. And you've seen the videos, you've seen maps of the route. You know, he pulled out of Chick-fil-A, he goes through the U-turn up to the intersection. And Dr. Brewer explained to you, in as little as seconds, we can lose awareness. And we can forget what our intent is, our intentional plans. Seconds. And you heard that when coupled with a distraction, something that requires our focus or concentration, like the U-turn, it further promotes that loss of awareness. He's been through that intersection. Dr. Bruni told you, it's dangerous. You got to concentrate. You got to pay attention. And Ross has been through that intersection that U-turn many times. But it's different every time you go through it. Why? Because the traffic's different, and you have to pay attention. You have to concentrate. Seconds is all it takes to lose that intentional memory and slip into that habit, that routine of going straight through that intersection to work. And Ross does it all the time. And by the time Ross got to the intersection, he'd already lost awareness. He'd already forgotten. And by the time he pulled into work, he was already in his daily routine. The workday started. He talked about Cooper during the day. He texted about Cooper during the day. He saw images of Cooper during the day. But as Dr. Brewer explained, those weren't the kind of cues that challenged his memory, that challenged him that something's different. Something's not right. You see, he talked about his son every day. He saw a picture of his son every day. That doesn't tell him, I forgot to do something. It could, but it didn't. It wasn't the kind of cue that made him remember. Dr. Brew explained that we all have false memories. Talked about that. In this case in particular, Ross had taken Cooper to daycare so many times. He had lots of memories of that. And remember what he told Officer Piper? I swore I dropped him off. I could have swore I dropped him off. That's a false memory that Dr. Brewer was talking about. Now, he's a preeminent scientist and researcher in the area of memory. And I hope that you appreciate that we brought somebody like him in here to educate you on how memory works and how memory failure works. He's not a professional witness. But what he talked about was unrebutted. How we fall into autopilot. How distraction promotes memory failure. The fact that we have memory failure in mere seconds. And the fact that Ross would have had false memories. That's all rebutted. Unrebutted. Completely. The judge is going to charge you about mistake of fact. A person shall not be found guilty of a crime if the act or omission to act constituting the crime was induced by a misapprehension of fact that it would have justified the act or omission. If Ross got out of that car believing it was a normal day and had forgotten, believing, having every reason to believe Cooper was at daycare where he was supposed to be, that's a misapprehension of fact. And the law calls that a mistake, not a crime. I want to talk to you next for a few minutes about, and just so you'll understand, procedurally, I get to talk to you once. The state gets to talk to you twice. They get to split it up. So naturally, I'm going to talk to you a little bit longer. But I want to go over with you a couple of things of concern that I really think that you need to be very aware of and very skeptical about in determining the credibility of the state's case here. First thing I want to talk about is the placement of the car seat for making that 3D scan. Obviously, the state went to great lengths to make this 3D scan of the interior of Ross's car for the purpose of showing spatial proximity and sight, line of sight. To make that scan, what they did was they reinstalled the car seat to the specifications so that scan would be accurate. Detective Grimstead had taken measurements, and then they had photographs. They had photographs of how that car seat looked before, and photographs of how that car seat looked after Detective Grimstead had reinstalled it. And they were not the same. They were not the same. Remember the little demonstration with the car seat and how it had that base extender? Remember that? You'll see, that base extender changes the angle of the car seat. And without the extender, the car seat is leaning down more. With the base extender, it's leaning up more. Why is that important? Because that absolutely changes the line of sight. That changes what the driver may have been able to see or not see if they were looking. It's very significant. And all they had to do was look at those photos. That's all they had to do. Just look at the pictures and see they're not the same. The angle is wrong. And of course, you saw what happened in trial. We point out to the detective that, hey, this is wrong. You didn't use the one measurement to verify this. You didn't even know about the extender. Somebody had changed it. The bottom line is, they were prepared to come in here to this trial and share with you a scan, which was wrong. Which was absolutely wrong. That's what they were prepared to do. And if we hadn't pointed it out, that's exactly what would have happened. You would have been provided very false information. Of course, the state's going to stand back up and say, well, we took steps to make it right. This was an oversight. We took steps to make it right. So I think it's a fair question. I think it's a very fair question to ask. Everybody working on this case for the state, everybody involved, did nobody look at those pictures like we did and realize that it was all wrong? Nobody looked at it? Were they going to catch it? I think that's a very fair question you should ask yourself. So the state then created another second 3D scan while we were in trial a couple weeks ago. And through that scan, of course, what they want to suggest to you is that Cooper's head is sticking way up above the top of the car seat so that he had to be seen. Had to be seen. Of course, what you have to do is you have to assume, again, that all measurements are correct. All measurements. Car seat, doll, everything. And you have, but you have no evidence of how that doll was placed in the car seat. None. Was that doll propped up? Real nice and high in that car seat? Or maybe more like a real child slumped down. We don't have the evidence of that. Or you can look at the evidence of what Cooper actually looked like. $174. This was taken by Leanna Taylor's mom on April the 20th. She looked at her phone, verified through properties. This is when it was taken. She remembered when it was taken. She was with her grandson on June the 5th again. And she said, this is exactly how he looked in the car seat. Leanna Taylor told you the same thing. She said, this is how he looked in that car seat. Not like this. So you can assume their measurements are right, you can assume that they placed everything just right, or you can rely on what Cooper actually looked like in that car seat. I want to show you something else. Let me show you something else about the scan. We want to be accurate, right? I mean, that's what we heard from the state. We want to be accurate. Take a look at this. Take a look at Cooper's feet. Notice. Nice white socks. Nice white socks. Oh, this is a good picture to show you just how dramatically different the evidence would have been in the original scan if we hadn't pointed out the error. See how different? So look at this. That almost looks like neon coming off that child's foot, doesn't it? Bright white sock. Why? It's easy for us to see a nice bright white sock. No tinted windows. Light coming in. It's all illuminated in a bright white sock. Almost looks like you can see it from across the room, doesn't it? The problem is that's not accurate. Go ahead. That's what he was wearing. Blue shoes. Gives a much different visual impression than white socks, doesn't it? Listen, that scan was made for the purpose of showing you, what Ross might be able to see. That's the purpose of it. And what they do is, bright white socks, brightest thing on the screen, when in fact, he was wearing dark shoes. It's a very different visual impression. Optically, gosh, it'd be hard not to see those socks, wouldn't it? Pretty slick. Heard lots of testimony about after lunch, Ross going back to the car to drop off light bulbs before he went inside to work. We heard that after seeing the video. Detective Stoddard testified in July of 2014, and he said, he's all the way inside the frame. He's in there. He has a clear view. You didn't hear that what he had previously testified to was, well, while Ross was walking near the car, he has a clear view. No. No. Detective Stoddard swore under oath. He's in there. He has a clear view. A clear view while he's inside the car. Let's look at the video again. Let's see what Detective Stoddard saw. Thank you. One arm. Dump those light bulbs. Door closed. Seconds. And as you can see for yourself, he's not in there. He doesn't have a clear view. You can see very clearly, very, very clearly. His head, it never goes, Ross's head never goes below that roof line. So I think it's a very fair question to ask you this. When the detectives in this case take the stand and they swear to tell the truth, the whole truth, and nothing but the truth, is it? I think that's a real fair question. Or are they going to tell the truth for their theory? You're going to have to decide who's credible. Let me help you answer that question. You remember we heard from Greg Sanders? He was the corporate security officer at Home Depot. He spends his days looking at these kinds of videos. And he looked at this video. And what did he say? Saw one arm go in the car. Head never came below the roof line. He's not inside the car. Of course, Mr. Sanders isn't a Cobb County police officer. He's got no stake. Recall the testimony of Walter Pineda, who did the photo enhancements on these very same Home Depot surveillance videos. What did he see? One arm go on the car, Ross's head above the roof line. He's not a Cobb County police officer. It's very clear. Ross never looks in that car. He never gets in that car. His head is never goes below the roof line. He never hesitates. It's 3 or 4 seconds. He never looks back. You yourselves have a chance to view that car. We call it a jury view. And every one of you saw the car seat in that car. Easily. Because you were looking for it. Every one of you knew that car seat was going to be in the car. Every one of you was looking for it. You knew that you were there for the sole purpose of doing just that. Of walking around that car, see what you could see, to see if you could see the car seat. Maybe substitute what you saw for what Ross might have seen or might not have seen. Some of you actually walked towards the car, as somewhat as Ross did in the video. Some of you actually got in the doorway, kind of up in the car. And I saw a couple of you actually turn your head and look toward the back. Of course, Ross didn't do any of that. But it's easy to see what you're looking for. In fact, it's impossible to miss what you're looking for. But Ross wasn't looking for the car seat. He was strolling up to open that door and toss those light bulbs in and go back into work. He didn't have a laser focus through the window looking for it. He didn't lean in. He didn't look back. Was the glare on the windows exactly the same as the day you were there? When Ross opened the door? Were the windows mirrored out, as they sometimes do in the sun? And what about all those people who we saw? I showed the video of the car in the parking lot all morning long. Remember that? Remember that? All those people who walked all beside and up against Ross's car all morning. They were as close as you were. Some closer. Some actually brushing up against the car. They were real close. And not only was the car seat in the car, Cooper was in the car too. And why didn't they see the car seat like you did? Because they weren't looking. How do we know that Ross didn't see? How do we know he didn't see Cooper? Because he didn't freak out right there in the parking lot and pull him out of the car like he did at Acres Mill. That's how we know. Your testimony, Detective Stoddard suggested to you that when Ross walked back to the treehouse after closing that door after lunch, it's possible that he turned to look at a person walking past him with his peripheral vision. And of course, what they want to suggest to you is he's got knowledge that Cooper's in the car, and so therefore when somebody walks by, he's checking them out. That's what they want to suggest to you. Takes the stand and says, it's possible. It's possible. Take a look at the video again. Ask yourself, being misled again? It's real clear he doesn't turn his head. It's real clear he can't see something that's behind him. And it's real clear he's on the phone. Two witnesses you heard from that were not police officers, Greg Sanders and Walter Pineda, they looked at that video. No, they didn't see him turn his head. They didn't see him turn around. They didn't see him look behind him. Detective Stoddard testifies, I can't tell if he's on his phone. I can't be sure. I want to be accurate. But his own report says Ross was on the phone. And we've got a video of Ross walking into the building on his phone. You kind of get the feeling that maybe detectives are going to say anything they can to make it seem that Ross is doing something suspicious. We'll talk to you real briefly about this phone call. The state put in Ross's AT&T phone records to show there was a 5-minute call to Little Aprons there at the scene. Ross told the police from the beginning that he had been trying to call Little Aprons to warn off that his wife was coming. And of course, in the panic of that moment, doesn't that really seem like the most logical thing that you would do? You know your wife is going to be headed over to the daycare to try to get them and say, hey, head her off. She's going to freak out when she gets there. But what you heard was this. It was so suspicious because they couldn't get anybody to admit who was talking to Ross at the daycare. And you heard that Detective Stoddard interrogated that poor old Michelle Gray. She had to get a lawyer and go to Atlanta to be interrogated. And she was warned that obstruction or making a false statement would be a crime. Well, we got some evidence about this. You pay real close attention to your This is 72. 72. And this is the call log. And it shows the time of that phone call. Or 25:57. Just before that, there was a 26-second call to Home Depot, to Little Aprons. Okay. Phone call at 4:25:57, lasting 5 minutes and 13 seconds. But then we get CAD. This is the recording of all the activity of that call out to the scene. And what do we find out? We find out that at 4:27:04, Ross is detained. He's at 73. He's detained. So we'll do the simple math. And what that tells us is, here, this suspicious phone call, Ross was in custody. He was actually in custody for at least 4 minutes and 6 seconds of the call. And what it also tells us is this. Before we interrogate poor old Michelle Gray, maybe somebody should have just looked at their own CAD report. They didn't bother just to check the 911 records. Why? Well, this isn't suspicious. But maybe he's hooking up with some woman at Little Aprons. And that's really what this was all about. They want to try to prove that he's hooking up with Michelle Gray. That's a lot more suspicious. That's why they went down that route. You heard the state's theory all along has been that Ross intentionally killed his son to live this life free of responsibility of wife and child so he could live child-free. But we also heard from Detective Stoddard during the trial that Ross's former wife, Leanna, has been a suspect during the entirety of this investigation. Not actively right now, but he said she's been a suspect during the entire investigation. They just didn't have enough of a probable cause. Well, if the theory is that Ross murdered his treasure to free himself of this marriage to Leanna, how in the world could she be involved in a conspiracy to do that? How is that possible? Leanna's going to assist Ross in murdering their little boy so that he can free himself from a marriage to her. It sounds absolutely ludicrous. But if Leanna has been a suspect for 2 years, that's what you would have to buy. If she's been a suspect for 2 years, that is the cockamamie story that you have to buy. It's absolutely ridiculous. And yet, with no evidence whatsoever, she's been a suspect. Did you kind of get the feeling that the detective was really just itching to tell us that she's still a suspect? Did any of you get that feeling? We just hadn't had probable cause. Like Ross, she didn't cry enough in front of them. She didn't grieve enough in front of them on the worst day of her life. So she's a suspect. You heard in the opening statements that there was going to be testimony about a stench of death in Ross's car. This suggestion obviously being that, Ross had to know there was a dead child in his car. Had to. If there's a stench of death. You heard that in July of 2014, Detective Stoddard testified in a hearing that hours after Cooper had been removed from the car, he noticed a, quote, a foul odor. It smelled like decomposition or death. And then we heard about the detectives meeting that happened about a year later, which included some discussion about this foul odor of decomposition, death. And shortly thereafter, this is a year later, Detective Grimm said, writes a report that, oh yeah, I forgot to note in my report that there was this odor. And their boss, Lieutenant Farrell, who concluded that this couldn't be an accident before any investigation was done, he wrote a report, and he said he smelled a unique smell of the deceased body when he got in close proximity, not in the car, in close proximity to the car. And that's real important. He said he even smelled gases coming off the body. Well, it's a funny thing. Nobody else smelled this odor of death and decomposition they're talking about. Remember Shumpert? Shumpert was the CSI detective. He was right there, down there with Cooper's body for an extended period of time with the investigator from the medical examiner's office, which is in the doorway of the car. He went all around taking pictures for an extended period of time. What did he tell you? He smelled a diaper. He smelled a diaper. The medical examiner investigator, Martin Jackson, his job is solely to work death scenes. That's his job. He told you he grew up in the funeral home business. He smelled urine. Firemen, EMS, responding officers, bystanders. One person testified they smelled soiled diaper. Most significantly, Dr. Chris, the medical examiner, who had examined tissues under a microscope in this case, told us, don't believe you have decomposition smell per se. I don't believe the odor would be the same as the odor of a dead body, like in his morgue. Maybe a stale odor of breathing and sweating and urine and flatulence. Of course, after the medical examiner testified, Detective Stoddard kind of backed off his prior testimony from 2014 and explained, well, when I said decomposition, I didn't mean that like in a medical sense. I didn't really mean decomposition when I said decomposition. And ultimately, he finally just agreed, yeah, it's possible also. It smells funny. He finally just agreed, yeah. Possibly didn't smell funny. Hardly the resounding stench of death that we heard about in opening statements. But I think the takeaway from this is that those detectives most invested in the case, in the outcome, Detective Stoddard, is false. They reported smelling what they wanted to smell. Despite what everybody else could smell, they reported what they wanted to smell. Why? Because it fit their theory. State a post-certified officer who does computer forensic work named Jim Persinger. And what he had to report was that he looked at the Dr. Ernie Ward PSA video and confirmed that Ross had accessed the video just as Ross told the police. And he confirmed that Ross did not search for it. He clicked on the link on the Reddit page. And listen, there's an enormous difference that I don't want you to lose sight of here. There's an enormous difference between pulling your homepage up or your Reddit page and seeing a trending video and clicking on it to look at it. And Googling, typing in specific words, looking for hot car video or whatever the words may be. There was no search. It was a trending video that came up on his page. Click it. Watched it on YouTube. Jim Persinger also confirmed that Ross did not create this whisper, which is this is the sort of the crown of the state's case here. Ross didn't do this. Didn't do it. He confirmed that Ross did not create that. But what was the real reason for his testimony? Why was he here? If you recall that Mr. Persinger kept saying he dug a little deeper. Dug a little deeper. And Mr. Persinger did a little demonstration where he put up on the screen, on the Mondo pad, he put up a screen about a website. Talked about a website called Griffin Psychology that he found in Ross's preferences. And you've heard us talk about this a little bit throughout the trial. This is real important. I want to tell you why. He said he noticed there were changes to the website address in Ross's preference. And when he looked up the content of the Griffin Psychology website, it talked about jury selection, interviewing witnesses, forensics. Remember back to when you heard that testimony? It sounded real suspicious, didn't it? words came out of his mouth. Jury selection, interviewed witnesses, forensics. And that sounds really suspicious. The person who told you that showed that Ross was crafty. Because after all, he had dug a little deeper, cross-referenced. And then, after lunch, he got back on the stand, and he had a completely different story. He told us that, well, he reviewed the contents of the Griffin Psychology website that morning for his testimony, in case Mr. Evans or we asked him about it. And it was just an example. It was just an example. Of all the thousands of URLs that were in Ross's devices, that's the one he picked. Talk to you about the contents of it. Let me say this just as plainly as I can. There was no legitimate reason whatsoever for him to discuss the contents of the Griffin Psychology website. None. There was no example to be made of anything. None. Nothing. Except to suggest something nefarious. Jury selection, interviewing witnesses, forensics. Of course, we now know the whole little demonstration was basically designed. No, it was a fraud. It was a fraud. Let's call it what it was. Ross was a web developer for Griffin Psychology. He's the one that worked on their website. They were a client. And what you later heard was Ross's emails and Google chats and the history of Ross's access to the Griffin Psychology site would have made it absolutely impossible for somebody like Jim Persinger doing a forensic review not to know that Ross was the web developer for that site. I think you need to keep that in mind, that little show that was put on. You keep that in mind when you consider credibility. I told you that Ross searched for a product called a VPN, a company called PrivateInternetAccess.com. It's a virtual private network. Well, it's a tool that's used to secure information across users, share data with others while working in the public without people hacking, basically, to get your information. And of course, Persinger brought that up to you and suggested that Ross searching for this product was somehow nefarious, somehow illicit. But of course, what we find out is Ross is a web developer, and he and his friends are building a business, a web development business. And they've got clients that they have to secure information. And they work at different locations. And they have to communicate about these things privately. And they were in the process of pursuing clients such as Dr. Keaton. And what we learned was that this VPN, this is exactly the kind of product. If you remember, we heard testimony from Scott Moulton, from Andre Brown, from Giovanni Etienne. This is exactly the kind of product you would use if you're in that business. There's nothing suspicious about it. And if he had actually dug a little deeper, like he said he did, it would have been obvious. Mr. Persinger makes an enormous deal that Ross had manually cleared his cache or web history in his Google Chrome browser more often than he cleared in some other browsers. He found it so suspicious that he threw around the words crafty and Dr. Jekyll and Mr. Hyde. But what we heard from Andre Brown is that Google Chrome is the preferred browser that they use at Home Depot when they're doing their IT work, their web development work. And he explained to you, you have to manually clear your cache. You've got to clear this stuff out. It's part of the work. We do it all the time. There's nothing suspicious about it at all. Scott Moulton told you the same thing. And he explained that you clear your cache from your phone as well. If you're going to be testing any site you're working on locally, you have to clear the cache from your phone. You heard from Scott Moulton, clearing your cache. It doesn't wipe your computer. It frees up memory. According to Persinger, this very routine part of being a web developer was crafty and made Ross like Dr. Jekyll and Mr. Hyde. He told you that Ross searched for how to survive in prison. Well, we know that was false. Even Detective Starter told you that was an error. Detective Yeager told you that was false. Scott Bolton told you that was false. Persinger said that he searched it. I submit you were misled start to finish with the entirety of his testimony. You heard from a witness named Wesley Houston, security guard at the tree house. And we saw that very short video clip of Ross leaving for the day, walking through the security. I want you to remember back to Wesley Houston's testimony. What did he tell you? He said he'd never talked to Ross before, but on that day, it was like a public service announcement. Ross came through and, "Hey, I'm Ross Harris. I'm going to the movie with my friend, Winston Mullins." Making a grand announcement. The suggestion, of course, being that he was letting everybody know to kind of set up his great find moments later when he got down the road. He told you that he had actually reviewed his interview the morning he testified here in the DA's office. Wesley Houston did. And of course, it was all a lie. It was a lie. When we talked to Detective Stoddard, he confirmed that Wesley Houston never told him that. In fact, what Wesley Houston told Detective Stoddard was that it was Leanna Taylor who came in later that afternoon and said her husband was Ross Harris, and that her husband Ross Harris had gone to the movies with a guy she thought was named Winston Mullins. So why is this a big deal? So what? The reason it's a big deal is the state of Georgia put that man on the stand. And what he told was not the truth. And they allowed him to give that testimony, and there was no effort to stop him in any way. You are entitled to consider that when you are thinking about the credibility and what the state's trying to sell you in this case. You heard about Ross clicking the posts in child-free subreddit, allegedly some forum for those people who don't want children. And we heard that in July of 2014, Detective Stoddard believed that this was evidence of motive. Then at trial, you remember Detective Yeager took the stand and he presented these child-free sites. Put it up on the Mondo board. And as it turns out, what he told you was, yeah, Ross clicked on these. He clicked on these posts in this child-free subreddit. Of course, as it turns out, the state had information through these Google chats that between Ross and Alex and Winston, that it was Alex Hall who shared this child-free link with Ross. It was Alex Hall who did that as a joke moments before Ross had gone and clicked on those posts. And what was Ross's response? Grossness. This evidence of motive clicks on child-free Reddit for a big fat joke that Ross found gross. And Detective Stoddard couldn't tell us when he found out that information, when he knew this grand evidence of motive was bogus. But we know this. He Never wrote a report about it. I think it's fair for you to ask yourself, were the police just hoping that Kilgore wouldn't find out about it? We did. You've been misled. You have been misled throughout this trial. Thomas Jefferson. I consider trial by jury as the only anchor ever imagined by man by which government can be held to the principles of its Constitution. As jurors, your responsibility is to hold the state accountable. You hold them to their burden. And if you recognize or see a pattern of misleading in any way, effort to mislead you, you are to remember that when determining credibility in that jury room. The whisper image. In opening statements, that was front and center in the state's case. I hate being married with the kids, the novelty is worn off, and I have nothing to show for it. That's the centerpiece, okay? And the centerpiece isn't even something that Ross wrote. Of course, it's blown up to the optics of it. It's big, sounds terrible. But think about it. In all of these whispered posts that you've gotten, all these responses, all of this material you've received, you never saw Ross say anything like that. But he did respond. And what did he do? Well, he does what Ross does. He engages. He tries to connect, reaffirming responses. I mean, why does he even do these whispers? What would anybody do? They want to connect. They want to engage. I miss having time to myself. I miss having time to myself and going out with friends. That sounds exactly like something Ross would say. My wife gets upset when I want to go out with friends. It certainly sounds like something Ross would say. I love my son and all, but we both need escapes. Sounds exactly like Ross. But what he doesn't say is what the state suggests that he's saying. I love my son and all, but I'm about to murder him in the next 15 minutes. That's essentially what the state is telling you that says. Yeah, not bad, but the response. I love my son and all, but I'm about to murder him in the next 15 minutes. Of course, he doesn't say that. And it doesn't suggest that either. And then the last bit of the dialogue was agreed, hug, we both need that. So here's what you're to believe that Ross has done. He is in the throes of committing a murder. He is actively in the throes of committing a murder. And he responds with hug. Hug. It's preposterous. It's absolutely preposterous. And then the last line, we both need that. That's Ross being Ross. You're just connecting with somebody. You're going to have all of these whispers to look through. You're going to see that's the constant thing throughout. It's connecting with somebody. There's evidence that Ross responded to whisper posts all day long. This wasn't the only one. He was doing this all day. All morning. Throughout the day. Random subjects, trying to connect. You've heard he talks all the time. When he doesn't have somebody to talk to, he's connected online. In an opening statement, we showed you several of these posts, these whisper posts that he responded to. And apparently I got the time wrong on one of them in opening. Doing the UTC calculation. Of course, y'all saw it during the trial. I couldn't keep my left from my right a couple of times either. The bottom line is, we put all those in evidence. We put those in evidence, those whispers that he had done on the 18th. And you're going to see for yourself. This was just one of many random whisper posts that he responded to throughout the day. And the state wants you to completely ignore the sentiment, of course, I love my son. And they just want to focus on this word, escape. Just focus on that word. Escape. And they want you to make this leap. The word escape there, what it really means is murder. Because that's the little bridge that has to be built to get from the word escape to what they're trying to tell you. It doesn't say that. We showed you the post from 10:45 where he says Cooper's awesome. Now the state doesn't want you to believe that that's true. Well, that's not true. Escape means murder, but when he says his son is awesome, that's not true. Only the things we want you to say is true, be true or true. And they want you to ignore that he was planning a cruise with Cooper hours earlier. Ignore that there was no person on the planet who could, that would say that Ross had ever said an unkind word about his son. Ignore that even the woman who he humiliated in front of the world, that's why, come in here and tell you he loved that little boy more than anything. The judge is going to charge you on something called grave suspicion. And what grave suspicion says is this. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Grave suspicion. Well, kind of bothers me is I've got some suspicion. The police department had a lot of suspicion. Got all these things, but some of them just don't add up. So I don't know. It's going to tell you that that is not sufficient. That is not sufficient to convict a grave suspicion. That is not sufficient to undo the state's burden to disprove that this was an accident. The burden is on the state. The state's told you in opening and in closing that their case is about theft, deception, and double life. But the truth is, this case has always been about demeanor and dirt. Ross didn't act the way they thought they should. He didn't talk the way that they thought he should. His demeanor wasn't how they thought he should have acted. Even though he was frantic at the scene. Frantic. Screaming. Even though there's plenty of video of him weeping aloud when he's alone. Turns around in the police car to see where his son's being tended to. Of course, that's suspicious to them, even though every one of us know that's exactly what anybody would do. They would turn around and look and see what was going on. But for Ross, it was suspicious. Neither here, Leanna cried while they were being interviewed, so that was suspicious. He's inconsolable when allowed to speak with his wife. His daughter didn't see any real tears. We don't have to bring a psychiatrist in here to explain to you what you already know. We don't know. None of us know how we would react to any particular trauma. We don't know. We think we do. We don't know how anybody would react. Because everybody reacts differently. Ross and Leanna, they reacted very differently than a lot of us might. We don't condemn them for that. One thing we do know is that Ross had a very different kind of personality from all of his friends and family we talked to. He was a different guy. His wife told us he was very even-keeled. He wasn't a crier. She had never seen him cry anything like that. If you want to watch that again, you can ask and see a broken man. Inconsolable. And no matter what words he said, it's not going to satisfy the police department. It's not going to satisfy the state. No matter what he said, it was the wrong thing to say. She had never seen him like that before. Officer Stoddard, Detective Stoddard doesn't know Ross. Officer Parker doesn't know Ross. That kid that sold his story to the National Enquirer, he don't know Ross. But Ross's demeanor wasn't what they thought it should be. You ever known anybody that was a little different? You ever been the one that was a little different? So ask yourself this. Is there any evidence that Leanna Taylor is guilty? No. Yet she exhibited far less emotion than Ross did. Far less. She was under control, very strong in that room. Because she was obviously in shock. But because of her demeanor, she's been suspect. State is really hurt about Ross's extramarital sex life and sexting. We told you in opening. He's absolutely earned every bit of the shame coming his way. And the shame just kept getting heaped on him. He's earned it. No doubt about it. His adultery and sexting is reprehensible. Period. It's despicable. And I've got to justify it anyway. The state spent days in this trial dragging these women out here that he had hooked up with or sexted with to essentially bury him in a mountain of his own sin, his own sexual sins. But none of that has got anything to do at all with Ross forgetting Cooper on June the 18th. It hasn't got anything to do with it. Nothing. How does Ross getting fellatio in a car in Tuscaloosa a year and a half before Cooper died, how has that got anything at all to do with Cooper's death? We all see exactly what this is all about. The state wants to bury him in this filth and dirt of his own making so that you'll believe he is so immoral, he is so reprehensible that he could do exactly this. That's really what they're trying to say. Demeanor and dirt. The problem is the evidence that Ross Love Cooper is unrebutted. Their presentation of demeanor and dirt is desperation. I want to talk to you real briefly about the options in this case. All right, so this is going to be the verdict form you're going to have. It's going to look like this. All right, and it's very easy to read. It's got the counts laid out. Count 1, malice murder. 2, felony murder. 3, felony murder. And again, let me stress to you, they're all the same. Murder's murder's murder. There's no grades. This is just the same as this. It's just the same as that. Okay? And then counts 4 and 5 are cruelty to children in the first degree and cruelty to children in the second degree. Okay? And I'm going to ask you to very simply go into that room and write 2 words for each of those. Not guilty. Because the state's burden is to prove beyond a reasonable doubt that Ross is guilty. But more than that, it's also their burden to disprove beyond a reasonable doubt that this was an accident. They have to disprove it. And they haven't done so. 2 words. You're not to worry about what anybody else is going to say. You're not to worry about media or your family or anybody else who hadn't sat in these seats that you have. Because in a case like this, the easiest thing in the world to do is go with the flow. Let's just go with the state. Compromise and just find him guilty on something. You know why? Because nobody's going to question you. Your husband's not going to question you about that. Your wife's not going to question you about it. And we have presumption of innocence in this wonderful system that we have. And as true as it is, and as much as we believe in it, in the back of our minds, when it's a real serious charge, we kind of think maybe there's an expectation that we're supposed to find somebody guilty of justice. For humans. I want you to know that justice isn't served only by finding somebody guilty. Justice is doing what's right. Justice is holding the state to their burden. What could possibly be more just than saying to the state of Georgia, we have followed the law. We've held you to your burden. And you just haven't proven it. You haven't disproven this was an accident. What could possibly be a more beautiful example of justice than doing the hard thing and writing those 2 words? The state hasn't proven it. And because he's not guilty. The last 3 counts involved criminal intent to commit a felony, sexual exploitation, dissemination of harmful material to minors. You get back there, look through the evidence, and you decide the state's proven their case on that, you would write the word guilty. Ross Harris, who will reap the whirlwind. Reasonable doubt. Presumption of innocence. He is presumably innocent unless and until the state proves him guilty, okay? Defendant enters upon this trial case with presumption of innocence in his or her favor. This presumption remains with the defendant till it is overcome by the state with the evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime as charged is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. Reasonable doubt. What is reasonable doubt? Let me see the, this way. The state is not required to prove the guilt of an accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from the consideration of the evidence, a lack of evidence, or conflict in the evidence. Overwhelming evidence that Ross loved Cooper. Ross was planning a family cruise with Cooper. No effort to hide the car. He put it in the middle of the lot. Unrebutted expert testimony that memory failure occurs within seconds. No effort to delete the whisper of kick-outs from his phone. No effort to wipe the hard drive or history of the PSA video. Searching for a home in a good school district for Cooper. Changing routine that day promoted memory failure. Ross tried to get Elizabeth Smith to hook up with him that very day. Ross had nothing to gain by killing his son. These are just 10 reasonable doubts. Do you have any doubts? You only have to find one. Go ahead. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you should acquit the defendant. But if that doubt does not exist in your mind as to the guilt of the accused, you would be authorized to convict. Authorized to convict. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit. If the state hasn't proven it, and they haven't disproven the action, it is your duty under the law to write 2 words: not guilty. We talked about accident. You read this charge, the accident. Go ahead. Hang on one second. Go ahead. Play the video. have a Ross and Brian and Carlos. We trust you.
Ladies and gentlemen, we'll take our lunch break. Close your notepads, keep it open on, and discuss this matter. Enjoy your lunch, enjoy each other's company.
Let's all rise for the jury, please. Please watch the step going down.
Break till 1:30. Everyone have a good lunch.
Thank you.